On May 3rd, the Trademark Trial and Appeal Board issued a precedential opinion denying an application to register a line of essential oil dispensers used to dispense pre-measured amounts of cannabis-based oil to a vaping or smoking device for dabbing on the grounds that such products are illegal under the Federal Controlled Substances Act. It's been known since the legalization of medical cannabis that it's almost impossible to get a federal trademark. However, here the applicant argued that an exception under the Controlled Substances Act makes these goods lawful under federal law and thus eligible for federal trademark registration. We are going to talk about this case next on The Briefing by Weintraub Tobin. I'm joined by my partner, Tara Sattler. Tara, thanks for joining us today.
Hi, Scott. Thanks for having me.
National Concessions Group sought to register the mark Baked and a stylized drop design mark for an essential oil dispenser. The trademark examiner assigned to the application contended that this oil dispenser is drug paraphernalia used in dabbing and thus is illegal under the CSA and refused to register the mark on that basis. Even though the applicant argued that the goods were intended for and could be used for legal purposes, the examiner looked at extrinsic evidence, including NCG's website and advertisements for the product, which supported the examiner's position that the goods were primarily intended to be used with cannabis.
Under Section 1 of the Lanham Act, the owner of a trademark used in commerce may request registration of its trademark on the principal register. Section 45 of the Lanham Act states that commerce means all commerce which may lawfully be regulated by Congress. If the record indicates that the mark or the identified goods or services are unlawful, actual lawful use in commerce is not possible and a refusal under Trademark Act Sections 1 and 45 is appropriate. Where the identified goods are illegal under federal law, including the CSA, the applicant cannot use its mark in lawful commerce.
Section 863A of the CSA makes it unlawful to, first, sell or offer for sale drug paraphernalia. Drug paraphernalia is defined as, quote, any equipment which is primarily intended or designed for use in introducing into the human body a controlled substance. Marijuana and marijuana-based preparations are controlled substances under the CSA. The denial of a cannabis-related application under the CSA is not new news to any trademark practitioner. What makes this case interesting is NCG's argument that the two exceptions in the CSA supported registration.
The two exceptions to the CSA are in Section 863. They state that the CSA shall not apply to any person authorized by local, state, or federal law to manufacture, possess, or distribute such items. The applicant here argued that the goods qualified for an exemption because applicant is authorized by Colorado state law to manufacture, possess, or distribute such goods.
This argument was a matter of first impression for the Trademark Trial and Appeal Board. This doesn't happen very often. And while that usually means that the TTAB will address and resolve the matter, in this case, the TTAB said that they do not need to decide the merits of applicant's argument. The TTAB said that even if applicant's interpretation of the exemption is correct, it's not entitled to the registration it seeks.
First, the applicant's application was not geographically limited to Colorado. A federal registration would give applicant presumptive, exclusive, nationwide rights to its mark in association with the identified goods.
And second, applicant's goods are not legal in other states outside of Colorado and maybe a few other states where marijuana is legal. Any authorization by Colorado of applicant's manufacture, possession, or distribution of its goods, the TTAB said, cannot override the laws of the other states or federal law outside of Colorado. So, despite some creative lawyering, it's pretty much still the status quo at the Trademark Trial and Appeal Board, and cannabis-related trademarks still can't be registered on the federal level.
Scott, are you surprised by the TTAB's holding and opinion that it issued here?
No, I'm not surprised here. I think the TTAB could have maybe done a better job of explaining the interplay between the exemptions in the CSA and lawful use in commerce, and why when an exemption is applicable, the product still is not lawful in commerce. I mean, they kind of came out and said it. They said, even though it may be lawful in Colorado, it's still not lawful in other states. And that means that it's not lawful in commerce that can be regulated by Congress, which is what lawful use in commerce is under the Trademark Act. But no, I'm not surprised. I think what it's going to take in order to get trademarks, cannabis-related trademarks registered at the federal level is marijuana is going to have to come off of the CSA as a controlled substance. And maybe that time will come, maybe it won't. But I do give an A+ to the applicants' attorneys for some very creative legal arguing here.
Yeah, I agree. And it just doesn't seem like the TTAB is willing to take a position on any of these topics that seem to be hot button or even slightly political, where states have differing laws than the federal government. So I'm not surprised here either.
Yeah, I agree. I mean, applicants like this need to seek state registration, state trademark registration in the states in which it's legal. But the result will be a humongous mess, because we'll have a patchwork of different trademarks in different states with different priority. And it'll be very interesting, because I believe at some point in time, marijuana is going to come off of the list of controlled substances. And at that time, it's going to be kind of a mess. But, more work for us and other trademark lawyers out there. So
a mess for another day.
Thanks, Tara.
Thanks, Scott.
Well, that wraps it up for this installment of the briefing by Weintraub Tobin. I hope you enjoyed our discussion. If you're interested in more content like this, well, subscribe to our podcast and our YouTube channel. And we have over 100 episodes for you to choose from.